I just have to extend your display.
You see it?
It says extend display.
C'est quoi?
No more, 343. Okay, no more.
Samsung? Does it show?
It was showing.
Is there an airplane? Samsung?
Yeah.
Is there a remote?
No,
It's working.
No.
Remote? It's working.
بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا محمد وعلى آله وصحبه وسلم. So Jazakallah khairan, thank you for coming. Alhamdulillah. This is our course or class in Islamic inheritance and the rules. And we'll tackle some of the some questions, inshallah ta'ala, that are common associated with the rules of inheritance, Islamic inheritance, inshallah ta'ala. So it's our pleasure that we have Shaykh Talal, Shaykh Ahmed Talal Ahdab, alhamdulillah, who's been a teacher, lecturer, scholar in our community for the last 40 years. And over the last 8 years or so, he's been teaching and professor in Zaytuna College in California. So alhamdulillah, he's with us. So we thought we would twist his arm, get him to come and teach the Islamic inheritance, following the last course that we did on Islamic wills with Brother Ayana, who's here, inshallah ta'ala. So combined, inshallah, they'll be able to answer, hopefully, inshallah ta'ala, they'll be able to answer your questions, inshallah ta'ala. I think he likes questions. I think he enjoys a lot of questions, actually. So feel free. Don't be scared of all the devices. He also likes a lot of devices. So alhamdulillah, we'll hand it over to Shaykh Talal.
بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا محمد وعلى آله وصحبه أجمعين. Can you hear me in the back? So welcome to this introductory session on the Islamic law of inheritance. This is the slide that Shaykh Zahir has prepared. So this talk is called Miras, and it's just an introduction, just an overview of the Islamic law of inheritance, the rules. So to begin, I'm going to begin with a disclaimer. In this session, we will not be able to give precise answers to questions. But what we'll do, we'll go over the method, and the answer you hear will be a draft answer. And this answer can be finalized with your local imam, Shaykh Zahir, and also the lawyer Ayana will be indispensable to finalize this answer. Another thing we need to do is to make sure that you harmonize with the law of the land. The law of the land, meaning Canada, if we live in Canada. But some families, the family are scattered between Canada, the US, Guyana, maybe back in India, Pakistan, maybe back in the Arab world, maybe in Somalia, and Ethiopia. You also have to make sure that you're harmonizing with the law of your own land. Your own land back home, if need be. I know if you're from Syria or Egypt or Lebanon or Kuwait or those countries, you need to know the law of those lands, their law of inheritance, because their law of inheritance is a hybrid between the four schools. So the answer you may get from your imam may not align perfectly with the law of the land, and it needs to be aligned. And finally, before we go on to the talk, there's something called the estate, and there's something called the earth or mawaris, or the wealth that will be distributed. Those two are not exactly the same. The estate is what we start with. When someone dies, whatever they leave behind is called tarika, it's called the estate. But before it gets distributed, there are some rights that need to be satisfied. some claims that need to be satisfied. So we'll have two parts. Part one is the theory, and part two is some examples, some cases. We'll have some cases also during part one. So in part one, we'll look at the historical context, i.e., what happened before Islam, what happened after Islam. We'll talk about harmonize it with the law of the land. We'll talk about the estate and the wealth. And then we'll cover the hierarchy of rights related to the estate. And when we deal about mawarith, there are 5 parts or 5 chapters of inheritance that those that are giving answers need to be aware of. The second part, we can take Q&A and cases. There will be some basic cases, maybe some more cases, and highlights. So for this session, the learning outcomes is we want to get an understanding of why do we need to study the inheritance law. Why should we spend some time? Thank you very much for coming instead of watching the World Cup. So yeah, if we're going to waste our time, we want to waste it on something useful, right? Then we look at the historical context. We want to appreciate why Islam did inheritance in the way it did. If we look at the practice of the pre-Islamic disbelievers, and then the practice after revelation was received by the Prophet ﷺ, one would be shocked. We also want to understand the philosophy behind the distribution of the inheritance share. What's the wisdom, what's the philosophy, what's the rationale? And also one of the learning outcomes is to get familiar a little bit with the Quranic verses. The whole inheritance law was summarized in 3 verses. 95% of cases that we face in the real world can be extracted directly or indirectly from these 3 verses. And the other 5% are the ulama, they have to dig deeper in order to find out the solution. We also want to have some idea about the mathematical engine and the adjustment that scholars will do in order to determine exactly the share of each and every heir. And we'll cover 3 things: Rad, Awl, and Tasheeh. So Rad, this is the idea of reduction, and Awl is an increase, and Tasheeh is a correction. Again, there are 5 parts or 5 chapters. So there are some postulates, some preliminary principles. Then we want to understand the map of the heirs, the beneficiaries and categories. There is one important chapter, is the chapter of exclusion. Without knowing who's excluded, who's not, we cannot begin to distribute the shares. We want to know who's excluded, whether fully or partial. And exclusion is of 2 types that we'll go over. Some people are excluded, i.e. they're barred, completely barred. They're completely disqualified. Even though they exist physically, they might as well not exist, because they're not going to participate in this at all. And some people are excluded either partially or fully, but they're there. And they impact others. Their presence impact other inheritors. And then part 5 is, what do we do with uncertainty? How do we distribute the inheritance when there's a lot of uncertainty? Is a person alive or dead? Is a person male or female? Is the embryo, the fetus in the womb of the mother alive, are they twins? Maybe in Canada you can find out if there is a single one, but if you live in a village somewhere else in the world, you don't know that. You don't know if she's carrying twins, you don't know if the baby is male or female, you don't know if upon exiting they're going to be alive or dead. So you have to account for all these uncertainties and come up with potential ways of addressing the issue. So, yeah, in conclusion, this is like there's a synthesis of fairness and justice that we want to get an appreciation for. And we want to divide the wealth and not be divided by the wealth. Some families divide the wealth, and some families take each other to court and sue each other and become divided because of inheritance. These are some questions that may come or came before. These are real cases, actually. The first case is, if an estate grows in value during a long legal dispute over debts, does that increase belong to the heirs or to the creditors? The munasakhat question is, how can we accurately distribute an estate when several generations have passed without a settlement? And I'll give an example now. Inheritance via contract. Can a person inherit from someone they never physically met based solely on a legal contract? An inheritance outside the family. Can the estate go to one family or even more families, multiple families, outside the family of the deceased? So instead of the inheritance getting distributed within the family, it gets distributed outside the family. Under what conditions, what scenarios can this happen? So one case is the 120-year-old estate. A great-grandfather died in 1890. The estate, which is property and money, wealth, and dollars, was never distributed. But by the time they sought a solution, so there's a great-great-great-grandfather who passed away, they never distributed the asset properly, and then next generation didn't do it, the next generation didn't do it, and now in the year 2000, they said we need to fix this. The great-grandchildren said we need to fix this. And by the time they wanted to fix this, there were about 400 descendants, many of whom were unsure of their exact relation to the deceased. With another case, it's a multi-million share calculation. This is an inheritance involving munasakhat, which is successive deaths before distribution. So the calculation was so intricate that it required multi-sheets, eventually resulting in the estate being divided into over 5.9 million individual shares. So imagine the estate is a pizza, and you divide this pizza into 5.9 million pieces. And some people may get just a small piece, a small tiny piece. Some people may get 5 pieces or 10 pieces or 20 pieces from those 6 million pieces. The American marriage case, this can happen. A man in a Muslim majority country married a woman, say in the US, via a proxy. They've never seen each other, they've never met each other, they've never consummated the marriage. Just a legal contract. And though they never met physically, she gave birth after 1 year. Now, legally, she's married to him, and her progeny will carry his name. So because the marriage contract, unless it's contested, and you have to go through a whole process, because the marriage contract was valid the child was legally attributed to him and became an heir. This is acceptable in the Hanafi school. There's a process, but it can be acceptable. In the other schools, they have a different process for it. Let's take some case studies before. Take a case, before we talk about the theory, these are just examples. Let's take a case where custody is involved. Let's say a man dies. Can you read? Is it legible from far? So X dies, leaving, say, a wife, a grandmother, and a grandfather, i.e., a maternal grandmother and a maternal grandfather. So let's forget the wife and other inheritors and just focus on the grandmother and the grandfather. What does the grandmother, the uterine grandmother and the uterine grandfather, what do they inherit?
You don't have those, they don't have son, they don't have their kids.
Do they have kids? For now they don't. They just focus on the grandmother, the uterine grandmother, and the uterine grandfather.
Who has died? Who has died?
Say
Is it
something.
the grandmother and the upper part of the family?
All relations are to the deceased.
Hmm?
All relations that we present are relations to the deceased,
Okay.
right? So this is a very good example. Like many people sometimes come to the Shaykh and they say, Shaykh, there is a person that died, and then there are two brothers, one mother, and two uncles. But when he says there are two brothers and one mother and two uncles, he's talking about himself. He says, my brothers. No, if you say two brothers, they have to be two brothers to the deceased. All relations have to be relations to the deceased. So in this case, actually, the uterine grandmother receives inheritance, but the uterine grandfather receives a big fat zero. There is no inheritance for him. Only the grandmother receives inheritance.
On what basis?
Eh?
On what basis?
On what basis? Okay, that's very good. That's the example where we want to show the rationale and the wisdom behind it. Because let's say there's a daughter, and the daughter is married, right? Then the daughter has a children, right? So upon divorce, the daughter, the custody of the children goes to the mother, which is the daughter, right? Now, a year later, the daughter decides to get married. If the daughter decides to get married, custody is transferred automatically to the uterine grandmother. And because of this transfer, the rule of inheritance, in anticipation of the financial burden or financial need, they will give the uterine grandmother inheritance, but not the uterine grandfather. But the case is not like this. I'm just focusing, just a loose example. Another example is if we have an aunt and an uncle. In many cases, the aunt and the uncle will receive a 1-to-1 ratio. So the aunt will inherit and the uncle will inherit, but it's a 1-to-1 ratio. And let's say somebody dies leaving sons and daughters, then the sons and daughters will receive shares using a 2-to-1 ratio. Actually, a 2-to-1 ratio is not a principle in inheritance law. It's not like a golden rule. The ulama describe it as ahwal, scenarios. It's a cases. Because only in 4 major cases, where the 2-to-1 ratio applies. So the uterine grandmother inherit, but not the grandfather. They both inherit equal share, and the sons and daughters inherit using 2-to-1 ratio. So let's go over why study inheritance. This is so why study inheritance? Did it stop? Can you see? Working? Okay. Why study inheritance? We study inheritance because in following the inheritance rule, we actually preserve family
I have
ties.
questions.
Yes. Yeah.
First of all, barakallah fi.
Yeah.
This is very sensitive point. I'm talking about myself.
Okay.
Me and my wife, we decided we have asset. We gave it to, went to the legal aid, the share and everything. We write down
Mhm.
based on Sharia.
Okay.
We wrote the property under my two girls. I have two girls and two boys.
Mm.
This is 2 years ago.
Okay.
Now we change our mind.
Okay.
They said no, those people they don't deserve nothing.
All right.
The boys they don't deserve. They are working, they have money,
Mhm.
they don't deserve. Those two girls are looking after us.
Mm.
So what we have to do and take off out before we die. Allah will not ask us, based on my wife.
Mm.
What we do, we are alive, we give to the girls as a gift.
Mm.
Whatever left money, based on Sharia, let them share.
Okay.
That's what she said. I said to her, no. Allah said, either they help us, they don't help us, they give us, don't give us. We follow the Sharia of Allah. Because Allah, tomorrow when we go there, nobody will help us.
Mm.
What you gonna say about this one? Maybe,
That's a very good question. It's a very good question. Mm. Yeah, we can talk about it maybe after, if you like. But the lawyer also will need to be involved. And Sheikh Zahir also will need to be involved. Mm. But in principle, whatever you give, yeah, you're not dead yet, right? Whatever you give in your lifetime, it's up to you. Up to you. What the Sharia demands is that we be fair and just toward our children. We don't want to be reactionary. We don't want to be at the same time. So what you feel is real. So all of these have to be taken into account. And at the end, it's going to be your decision. You have to make a decision, and you have to live with that decision. But we can talk about that. But yeah, why study inheritance? The inheritance rules actually do help preserve family ties. And the inheritance rules also ensure social and state stability. Because if families start taking each other to court and over inheritance or over dividing assets, the nucleus of a community and the nucleus of society is getting divided by the assets. So, but when everybody knows that These rules come from Allah subhanahu wa ta'ala, and they're there for a reason. There's a wisdom behind them. It preserves family ties, and it ensures that the nucleus of the community is preserved. We also want to study inheritance and have more people that know about the rules, because it's becoming rare. The Prophet ﷺ mentioned that there will be a time when people will be asking questions and they can't find anyone to give them the proper answer. So help maintaining family stability is something the Sharia wants from us as a community. Wants from us to set ourselves in a way that maintain family stability. Let's take a look at the historical context. So, in the pre-Islamic era, the pre-Islamic practice concerning inheritance can be summarized in one statement. The Arabs used to say, لا يرث إلا من حمل الغنيمة أو من حاز الغنيمة وحمل السيف ودافع عن القبيلة. That's the pre-Islamic Jahiliyyah practice. None shall inherit except those who seize the spoils, carries a sword, and defend the tribe. So before the advent of Islam, inheritance among Arabs was based basically on tribal strength and the ability to fight. So if you can fight, you can inherit. And usually in the pre-Islamic time, what they did, there was this monopoly on consolidating the inheritance in one hand, i.e. with one person. So usually the person who inherits is the eldest son. The eldest son who is a warrior, who is a combatant, and who is still active. And if he's not active, there's a hierarchy. So what they do is, if that's the case, then some people will be deprived. And those who are deprived are usually women, children, and non-combatant men. The inheritance usually goes, in the pre-Islamic time, to someone in the family hierarchy, like the eldest son. Or, if the eldest in the family, or the eldest male in the family hierarchy, like the brother, then the uncle, then the tribal leader. And it's one person. They thought, if we consolidate the inheritance into the hands of one person, we'll maintain also the tribe strength, or the family strength. And then Islam came. When Islam came, it did not abolish all the Jahiliyyah practice overnight. So Islam usually follows a gradual process. It does things in stages, like it did with khamr, with wine, like it did with so many things. So Islam did not immediately abolish all existing customs, but sought to develop, first of all, a noble character within the people and built their faith in the Meccan period. And it adopted this incremental change. So much like the prohibition of alcohol, inheritance laws were introduced in phases or in stages. So the first stage, stage one, the Quran began in Surah Al-Baqarah. As you know, Surah Al-Baqarah was revealed in the first year Hijri. It's a Madani surah. The first year and second year. Surah Al-Baqarah. So in this stage, the Quran now mandated a wasiyah for parents and kin and widows in verse 280 and 240. What does this do? This mandatory will broke the monopoly on the eldest son. So it's no longer one person, the eldest son, or whoever is the knight in the family, that can inherit. Now you have to write to wasiya, and it was mandatory. كتب عليكم. It was mandatory to write for your للوالدين والأقربين, and also for widows. والذين يتوفون منكم ويذرون أزواجا. They leave widows. وصية لأزواجهم. So when leaving a widow, now there is a will mandating that you give something to the widows, you give something to the parents, you give something to those who are your relatives. So the monopoly of the eldest son now is broken. The second stage took place also in the first 2 years of Hijrah, when the Muhajirin migrated to Medina. The Prophet ﷺ implemented a 5-step policy in Medina. And one of those policies is that the Muhajirin and the Ansar can inherit from one another. Another avenue for inheritance is the scenario of adoption. Prophet used to say, هذا زيد ابني يرثني وأرثه, prior to the Surah An-Nisa was revealed. And the third way of inheritance is this idea of alliance, tanasur. That's the second stage. And then in the third stage, Surah An-Nisa was revealed in year 4, between year 4 and year 6. And in Surah An-Nisa, basically all other stages were abolished, were abrogated, and replaced by the general principles of inheritance that are mentioned in verses 11 and 12 and verse 176. That's the historical context. So it broke away the monopoly, it broke away also the concentration of wealth. So in Islam, we want to distribute the wealth and the tarika, the estate, to as many people as possible. So Ashab al-Furud wal-Asabat are about 25 people. And Zawul Arham are 48 people. So if Zawul Arham also inherit, you're going to end up distributing the asset potentially to up to 73, 75 people. What's the philosophy of distribution? Again, it's a gradual process. So the principle of distribution is distribute the estate among people from inside and outside the family. Because usually the spouse, the wife or the husband are from a different family. So you distribute the estate within the family, but also outside the family through marriage, through a valid marriage. So the 3 reasons for distributing the estate: either kinship, nasab, lineage, or a valid marriage, or what they call patronage, some kind of loyalty between the master and the slave. When the master frees a slave, there is this loyalty that gets, and bond that gets developed between them, and that was one way of inheritance if the freed slave was to die and he had no heirs. There's a fourth way, the way of alliance. Alliance used to be practiced in Jahiliyyah time, used to also be practiced in the stage 2, if you recall, in stage 2, after Islam was revealed. So the question is, was alliance fully abolished? Or did Islam retain some form, even if minimal, of alliance? So in the Hanafi school, they maintain, Islam maintained some level of alliance as a basis for inheritance. But the majority of ulama, they disagree with it. They say Surah An-Nisa abrogated everything. So we have an initial stage, an interim stage, and then we have the final stage. In the final stage, the specific shares and fara'id were eventually revealed in the Quran, detailing the exact portion for each relative, which superseded the mandatory will for heirs as well as the stage 2. Now, how does inheritance work in Islam? The philosophy of the philosophy of distribution is based on 3 factors, and there's a 4th factor that Allama Muhammad Abu Zahra observed out of the 3 and wanted to make it explicit, but I forgot to include it. So, those that inherit, whoever is closer in degree or in rank to the deceased, they have a basis to inherit more. So the nearer inherit more than one who is remote. The second basis is financial need. Those who are, there's an anticipated financial need, there is a basis for them to inherit more. And you will see this embedded in the rules. And the third is financial burdens. Those who are, there's more financial burden on them, they inherit more than those who have less financial burden. And this translates into multiple rules. I mentioned here 10 rules, but there are more. And then there are golden qawa'id, golden principles that that form the basis of inheritance. Maybe we'll mention some of them as we continue. All right. So, the foundations of inheritance in Islam, inheritance law ensures wealth remains tied to duties, to obligations, to burdens, financial burdens, to maintenance duties. And the Qadi, the judicial discretion of the Qadi is paramount, because the Qadi needs to look at everything and see what's the best way of distributing this estate based on the rules in this particular case, if the particular case is not fully explicit. And ilm al-fara'id in general is a discipline of precision. So some golden rules, for example, there's a precedence of descendants. You know, some philosophers like Jeremy Bentham says parents should not inherit anything because they're dying. Why should they inherit? Only give the children. So that's his philosophy. And then John Stuart Mill followed the same philosophy. But in Islam, no. The inner family, you have a deceased, and you have descendants, progeny, children. You have parents. You have husbands and wife, and you have birther. The inner family, all of them inherit, but different percentages, depending on their anticipated either financial need or financial burden or whatever. Those with anticipated legal financial burden and or need may inherit more, and actually they do inherit more. Another principle, al-qatilu la yaris. A killer does not inherit from his victim, but not vice versa. The victim can inherit from his killer. How can a victim inherit from his killer?
The guy does the thing that causes the person to die, but it takes a couple weeks for them to die.
Yeah, if the killer dies first, then the victim, because he did not cause it, dies. No bequest in favor of a legal heir. So the will has to be given to other people, not a legal heir. All women inherit through fixed shares except for the pattern. If a female person had a slave and she freed him, then she inherits that person based on different criteria. All men inherit through residuary asaba except for the husband. The husband has a fixed share. So in the Quran, it specified the fixed shares. I wanted to make sure that those people will always receive a fixed share. Those that receive the remainders of the estate, they may receive more, they may receive less, they may receive nothing. But the fixed shares have to be distributed first. The nearer in degree to the deceased, remember, all relations are to the deceased. The nearer in degree to the deceased excludes the more remote. Another version of this, the stronger of blood tie excludes the more remote. So we have, for example, the idea of bunuwa, fatherhood. So the father will exclude the grandfather. Only one representative of fatherhood gets inherited. Same thing with children. The child maybe has another child, have grandchildren. The sons excludes their own children. So they receive the inheritance first because they have to spend it on their children. And when they die, their children will receive the inheritance. There's an exception here that the deceased brothers are not excluded by the grandfather. The grandfather is very tricky. Grandfather and grandmother are tricky. Grandfather is stubborn. He always gets something. He pokes his nose into everything. Now, when we talk about exclusion is a very important chapter, and we will see that the excluded can exclude. Although they are excluded from the miras, by their mere presence, they can exclude others from inheriting. Maternal siblings share equally. They get a 1-to-1 ratio. Now, what's the link? Now, if you look at this, financial burdens, financial need, and you start thinking, okay, what's the link now between inheritance and fiqh, chapters of Islamic law? Starting from ibadat, worship, until jinayat, and until the end of the whole many volumes on Islamic law. What's the relationship? What's the link? So, i.e., can I study inheritance law without gaining familiarity with the Islamic law in general as a whole? You say you're a shaykh, you're a lawyer, you're someone that you want to be, you want to practice this business. You want to become a practitioner. Okay, well, sorry to disappoint you, knowledge of Sharia is not optional. You have to know Sharia. Not only one chapter in the Islamic law you have to know, you have to be familiar with almost every chapter in the Islamic law, starting with ibadat. So imagine acts of worship. How do acts of worship relate to inheritance? Well, zakat, for example, if somebody dies without having paid their zakat, then their zakat gets paid from the inheritance before it gets distributed, or after it gets distributed, depending on the cases. Somebody dies without performing Hajj, then someone will have to perform Hajj from the estate. Somebody fasts, but they have fidya to pay, or they have kafara to pay. The fidya and kafara, if they die before paying the fidya and kafara, this will come from the estate. So one needs to be aware of all this before they start distributing the assets or the tariqah. Marriage and divorce is part of the, it needs to be all the intricate subtleties in marriage and divorce need to be known to the one who is practicing, who is a practitioner. And divorce can be raj'i or can be ba'in, can be revocable or irrevocable, and there are implications of that. Well, of course, pregnancy, inheritance is related to pregnancy. Is the fetus in the womb of the mother, is it a male or female? Is it alive or dead? Is it a twins? Is it no? And also custody. Custody, one needs to know the chapter on custody and the implications of custody on inheritance. Guardianship, wilaya. Wilaya has link to inheritance. Nafaqa, when you give alimony or you have to, give nafaqa to your dependents, and somebody dies, that's another chapter. Another chapter is homicide, criminology in the criminal law. Or if somebody kills someone by mistake, there is a blood money, the diya. One needs to be aware of the diya in the Islamic law and how what needs to be done in those cases. And if somebody dies before paying the diya, then and many other chapters. I'm just including. This is not exhaustive. And then all kinds of disasters, tornadoes, fires, pandemics, accidents, floods, earthquakes, and people die together. People die together. Remember the example we talked about, an example where someone dies and the money gets distributed outside the family, goes completely to outside the family. This could be the case of someone, let's say a father, a mother, a son and a daughter. They're driving a car. Somebody driving, his wife is beside him, and they have a daughter and a son. Forget father and mother. They have no father and mother. Let's just take a simple example. An accident takes place, and the husband dies first. The husband, everybody is about to die, but the husband dies first. Now, if the husband dies first, it means the other three will inherit. Then the son dies. 5 minutes later, the son dies. I mean, the other two will inherit. And then the daughter dies. It means the wife will inherit. And then the wife dies. Because the wife inherited the last, and she's from has a different family name. Now, whatever she inherited will go now to her family. And all of the estate gets distributed outside the original family. And there are cases where the estate gets distributed to 5 other families than the original family. So all these chapters, whether it's zakat or hajj or fasting or marriage or divorce or pregnancy or nafaqa or custody or hadana or wilaya, homicide, diya, and then all other al-harqa wal-hadma wal-harqa, those that die because of pandemic or accidents or disasters, and many other chapters. Are there any questions up here?
Yeah.
I'll have questions like every 15 minutes. Now.
So with regards to going to sell the family, does it depend on who dies last? So,
Of course.
so if the husband in your example died last, it would be for his part of the family, right?
Right. If the wife dies first, then the husband is going to inherit her. Right?
Yeah.
Then if the husband dies, then whatever he inherited will go now to his side, or whoever inherits it. So this is the case where the assets can go outside the family if everybody dies before the wife.
Right.
Before the wife.
Okay.
And it will happen that the daughter will get everything because she gets her portion, the fixed share, and then she gets something called rad. There is a return, everything, whatever remains of the asset gets returned to her by way of rad.
Okay.
So she ends up inheriting everything, the whole asset, and then she dies. So the wife gets a farad and then gets a return. She gets everything. Then it gets passed away to other families. Let's look at some Quranic verses. Any other question before we start? Yes.
Yeah, my point was regarding the last question that you shared. Can you put it again, just before this?
This one?
Everything.
Yeah.
Yes. Okay. I did not understand regarding the inclusion of marriage. You're talking about the one on the left side. You can see the marriage and let's say adoption. Or
Adoption?
No, what I mean is what exactly this symbol
Marriage?
The one next to the marriage.
Divorce. You know,
Oh, divorce.
Yeah,
Right.
divorce.
Let's say there's a person who dies.
Mhm.
The person was married before. He divorced his first wife.
Uh-huh.
He got married or he did not get married. What is the relationship of the divorce wife?
Uh-huh.
I mean, how is she end up getting the her benefit
Mhm.
from the husband?
Mhm.
Like she
If
is
he
already
divorced her
as
in
you
his
say,
last
one
life.
minute, just let
Yeah.
me complete.
Mhm.
She is already on the alimony. Okay,
Right.
so her alimony, let's say, will continue until what period? That is one of the legal
Yeah.
things. But if say she is remarried, what exactly is the stipulation in that?
All right. Right.
So the first point is that if this particular is the connection not over except for the alimony or any kind of maintenance,
Mm.
let's say the husband keeping the
Mm.
children,
Mm.
okay,
Mm.
or in the case when the mother is keeping the children. So what exactly are the rulings of that?
Yeah, in the case of divorce, there will be inheritance if he divorced her in his last illness. مرض الموت.
How much portion? How many percentage? Like
She
this
get,
person,
she gets
she's
she
already
gets a
divorced
percentage if she's
10 years back, or 5 years back, or let's say 1 year back.
No, let's say somebody divorces a woman, right?
Okay.
Because he doesn't want her to inherit from him, right? So
No, no.
he's freeing, he's avoiding to give her inheritance by divorcing her, right? And then dies. So the ulama in many schools, if he dies during her iddah,
Idda is out. Yes.
Yeah.
Let's see.
during her iddah, it means this is his last illness, and this is an indication, this is a sign that he divorced her to deprive her of inheritance. Mm. Then she inherits as if she's still a wife in that case. So one needs to be aware of these scenarios or these subtleties in those chapters. Not the whole chapter will be related to inheritance, but there is a portion of the chapter or some subtleties that will be related. And I've seen some scholars who've gone through each and every chapter and showed the subtlety in each chapter and its relation to inheritance. Naam, sister. Does that make sense? Does that make sense? Does it answer your question, brother? Yes, for the.
You said that the deceased brothers may not be excluded by the grandfather, but is that according to the Madhab and the Shaykh, but not Hanafi?
Yeah, we'll come to those details a little later. Yeah, we'll come to those details. What I present here today is going to be 95% Hanafi. Hmm? And if there's a deviation in other schools, then I'll mention it. And then if I make a mistake, inshallah, will correct me.
This is a big part with the brothers and the grandfather that was admitted.
Yeah.
The Hanafi was
This is just an intro, just to give an exposure. Maulana, now, here he is. We have a Hanafi scholar. Alhamdulillah, كيف حالكم سيد؟ الله يجزاك.
So, sadaqat is given to know the wafat.
For what?
Sadaqat that is given by the person passing away.
Mm.
Right? That is also not to be considered. So that the heirs have to be aware of that. So it has to be returned to its estate and redistributed.
Mm.
So is that something that people would typically put it in the will, and it's not executable by law? So I mean, in a scenario like that,
Right, right. That's where you need Ayana. Yeah. Ayana says he's at our service.
No.
He's going to find a way out of this. Inshallah.
One question.
Yes, Fadal.
A person who is a gambler
Gambler.
and taking drugs also,
Mm.
his family is being taken care of somebody else.
His family are what?
His family with kids taking care of somebody else.
Somebody else, right?
He is enjoying his better life with gambling and drugs.
Mm.
After the death of the father, he first to claim his inheritance. So what is the scenario here? Because somebody for the last 20 years paying money on his family. But after the death of his father, he comes forward, okay, give me my share. So what is his share now? Because he's a gambler, he's a drugs addicted, he's a 20 years, he's enjoying his better life.
Yeah, this is a very good question. Yeah, with this question, we need to understand the details. But if somebody is a gambler like you're describing, maybe in Sharia would be called safir, right? And يحجر على ماله. Somebody doesn't know how to manage his own wealth, then legally speaking, he should not. His account should be frozen, basically.
Pardon?
His account should be frozen and managed by someone else. If someone is not Rashid, not someone who doesn't know how to manage his own wealth, his own affairs, then usually there's a department for that in Muslim countries.
So he's not fully, drugs, he's a gambler. But in mentally he's okay. He's managing everything. But plus he is a gambler and he is taking drugs. But he's enjoying normal
He
life.
does not
Like
manage
much
it. That's an example. If somebody spend their time shopping and wasting money, they don't know how to manage their money. Somebody who's a gambler, they don't know how to manage their money. There's something that's driving them to do this all the time, and this also has connection to addiction. So we can look at it, inshallah, in more details. Now,
Maybe you would, your mom has country set up a trust for that person.
Yeah.
And spend on them or spend on whoever they have to spend on.
right. So you manage their access to the money.
Yeah, you make the decision for them.
Let's take a look at the Quranic verses. So there are fixed share in the Quran, the share of half, the share of a quarter, and the share of 1/8. The share of 2/3, 1/3, and 1/6. So there are people who receive, there's a group of people who receive fixed shares. And there are a group of people who receive the remainder. And there's another share here that's not mentioned in the Quran. It's 1/3 of the residue. That was practiced by the Khulafa al-Rashidun and then the companions. So in the Quran, what's mentioned explicitly are daughters, and then father and mother, parents, and then husband and wife, spouses, and brothers and sisters. Those, they always have to inherit. They can never be excluded. And then brothers and sisters, they could be uterine brothers, uterine sisters, paternal brothers, paternal sisters, and germane brothers, germane sisters, i.e. full brothers, full sisters, sharing the same father and mother. So this group, they always receive inheritance. The wife cannot be excluded, the husband cannot be excluded, the father cannot be excluded, the mother cannot be excluded, and the daughters cannot be excluded. Yes, what did I have? Immediate family and peripherals. So in verse 7-8, we see some general principles. Actually, Mawarith starts from verse 1 in Surah An-Nisa. So there is setting the stage and building up to verse 11 and 12 that is necessary to understand. It's very good to understand the transition between verse 1 to verse 10. But in verses 7 and 8, we see these general principles. And then in verse 11, part of verse 11 focuses on the children, sons and daughters. And it gives three options here, three examples. And the examples, I put them here in a table. For daughters, if the daughter is alone, وإن كانت واحدة فلها النصف. If the daughter is alone, i.e. in the absence of her male counterpart, then she gets a half. فإن كن نساء فوق اثنتين, if there's two or more, then they get 2/3. And if there is both عصبة بالغير, so they become عصبة because the male counterpart is present, in the presence of her male counterpart, then the asset gets distributed 2-to-1 ratio for them. 2-to-1 ratio. Again, there is financial burden and financial responsibility and financial need. Like a girl, usually when she gets married, she receives a mahar. When a boy gets married, he has to pay a mahar. And he also has other responsibilities in terms of nafaqah. Now, in the same verse, verse 11, the verse talks about the parents. The parents. وَلِأَبَوَيْهِ لِكُلِّ وَاحِدٍ مِّنْهُمَا السُّدُسُ فإن لم يكن له ولد لأمه الثلث فإن كان له إخوة فلأمه السدس. So this is the division. So the father gets a sixth in the presence of a male offspring. Gets a sixth and a residue in the presence of a female offspring. Gets the residue only in the absence of any offspring. And the mother gets a sixth in the presence of any offspring or in the presence of 2+, whether germane or consanguine or uterine. Yeah. And gets 1/3 in the absence of any offspring or in the presence of only one brother or sister. Then she either gets 1/3 or 1/6. So basically the minimum is 1/6, the maximum is 1/3. And for the father, the minimum is 1/6, and the maximum could be anything above this 1/6. But the residue could be below 1/6 sometimes.
Shaykh, what is the best way to do before you die?
Before you die.
Before you die.
You want to divide the
Allah
estate
subhanahu wa
before.
ta'ala will not ask you. He will not ask you. You can give them gift. You can do anything you want before you die. If you distribute whatever you have.
So if you made up your mind before you die, then I suggest you talk to this guy. You don't need Shaykh anymore. You don't need, Shaykh.
No, I want to see your.
You don't need any. I'm not a Shaykh. This is a Shaykh, and Shaykh Zahir is a Shaykh. So in verse 12, husband and wife are explained in details. So we have the husband. His share goes between 1/4 to 1/2. 1/4 if there's an offspring, and 1/2 in the absence of any offspring. And the wife, the same. Her share goes between 1/8 and 1/4. So in the presence of an offspring, she gets 1/8. In the absence of the deceased offspring, then she gets 1/4. She may have her own offspring, but that's different. And then we have the uterine sisters and uterine brothers. And in verse 176, this is called Ayatul Sayf. It's a verse revealed in the summer, it seems. And Sayyidina Umar radiallahu anhu, he asked the Prophet ﷺ about the scenario, and the Prophet told him, "Takfika ayatul sayf." So Sayyidina Umar went to the ayah, he went through it, he couldn't see the answer that he was looking for. So he went back to the Prophet ﷺ. And the Prophet told him, "Takfika ayatul sayf ya Umar." Takfika. Go and it's enough. You'll get the answer there. And he couldn't. Then the third time, he put his hand on his chest, said, "Umar, takfika ayatul sayf." He didn't want to give him the answer. He wanted him to think on his own. You can get the answer. And Sayyidina Umar, upon his death, he gave advice to his followers, and all the advice was around wirasa, around earth, around mawaris. He gave 3 advices. The first advice is, I will never give an answer regarding kalala, this verse. I will never give an answer regarding another scenario of inheritance. And the third advice, I will not tell the Muslims who they should choose for their Khalifa, which is another form of inheritance, right? Because it's a form of succession. Who's going to succeed you? You decide. Yeah. Now, before the inheritance, any questions before we continue on the Quranic verses? So, rights associated to inheritance. So, someone dies and leaves a tariqah. A tariqah is, or the estate, we call it the estate or tariqah, is defined as assets owned by the deceased at the exact moment of death. Anything acquired after death or anything the deceased did not own at the time of death is excluded. And there is a difference between tariqah and mal. And mal, wealth or money, has a specific definition in fiqh. So al-malu ma yamilu an-nasu ilayhi. So in the Hanafi school, they're going to say that mal is that their assets, basically their money, that the humans naturally incline toward and can be withheld or given, and crucially can be stored for a time of need. It can be stored. The majority of scholars don't include the last portion. It doesn't have to be stored. So assets that a human inclined toward can be withheld or given, and that's it. So there are implications for not adding the last clause. So there are hierarchy of rights related to the estate. When a person dies, their wealth is not immediately distributed to heirs. There's a specific sequence of claims that must be satisfied first. So usually there is tajheez. It's summarized in this verb, tadum. The ta, the dal, the waw, and the mim. Tadum. The ta is for tajheez. The dal is for dain. The waw is for wasiyah. And the mim is for mal. Mal is what gets distributed. So there's a difference between tariqah and the mawrus, or the earth that gets distributed. They're about the same. If the tariqah is huge, then the expenses of tajheez and maybe settling debts and wasiyah may be small. But if wasiyah is 1/3, then what gets distributed is only 2/3. So there's a specific sequence of claims that must be satisfied first. So one might think, okay, tajheez, burial preparations, and then dain, settlement of debts, and wasiyah, execution of will. But no, the scholars of fiqh, they like to spice things up. So they say, no, debts, we have debts to God and debts to human. Duyunu al-ibad and duyunu Allah Azza wa Jalla. Right? And then we have duyun ayniyya and duyun shakhsiyya. So they add another variable to confuse us. So let's go to the next one. Rights associated with tariqah. Using tadum, the majority of scholars will follow it's very straightforward. You do the ta first, you do the dain, you do the waw, and then you do the mim. The ta is tajheez, burial preparations, which is what? Ghasl, kafan, and dafan, and without extravagance. And then dain, settlement of debts to humans or to God. So if someone, for example, didn't pay their zakat, that's a debt to God. If someone didn't perform their hajj, that's a debt to God. And then you execute the will, and then you distribute whatever is left. No, the Hanafis said, no, we're going to do it in a more nice way. It's a nice way. So first, we do the dayn. We settle the debts. And duyun, the specific sequence of claims that must be satisfied, that first of all, you settle the ayniya debts, i.e. you settle the secured debts. So debts that are tied to a specific collateral, either a mortgage or something. This is the first priorities for Hanafis. And then you do tajheez. Then you do the funeral and burial expenses. So the cost of preparing the body, the shroud, and the burial. The Jumhur, the majority of scholars other than the Hanafis, consider this as the absolute first priority before settling the debts. So tajheez, which one to do first? Dayn or tajheez? And then the Hanafis move on to do duyun shakhsiyya, unsecured debts. So general debts owed to people or to institutions. And then you execute the will. You execute the will. Now, also in the Hanafi, debts that must be settled before anything is distributed are debts to humans. Debts to God, it's up to the heirs now to do that. So if you have good children or good heirs, maybe they'll do hajj on your behalf, maybe they'll pay your zakat on your behalf. If you want debts to God to be settled before anything is distributed, then you must include this in your will. So when in wasiyah you have the debts to God are under wasiyah. And in the old days, the Hanafis used to say, yujladu. They said, right, Sidi Abdul Wahid, said yujladu. Right. So this is the rights associated with the tarikah before it gets distributed. So then you execute the wills. So like in the Quran it says, min ba'di wasiyatin yusa biha aw dayn. So in the Quran it says wasiyah before dayn. But fiqh is dayn before wasiyah. Because in the wasiyah usually is voluntary. It's voluntary. And the Arabs at that time, they preferred the elder son, so even if you have a wasiyah, they don't pay attention to it. So Allah subhanahu wa ta'ala in the Quran, He made the wasiyah first to draw all, every readers to draw their attention that this is very important, it needs to be executed. And remember in stage 1, He made wasiyah mandatory. So they can't ignore it because the Arabs used to ignore wasiyah. It's voluntary, it's a voluntary bequest. And in this case now, you can write a wasiyah to non-heirs.
Shaykh, how it becomes wasiyah? Allah subhanahu wa ta'ala already mentioned the tarikah is supposed to be like a formula 6, 1 second, 1/3, 1/4, 1/6. Based on that, we calculate it, we give it to all mustahaqin. But wasiyah, this is his opinion. But for example, don't forget so and so, he had me 1/3. So he's supposed to give 1/3, not more than that. Right or wrong?
Yeah, continue. What's the question?
So the dayn of the deceased is supposed to be paid before. Because you saw it. And when you put him in the grave, the dayn is the first. Whoever has dayn, it doesn't mean the Hanafiya or no. is all based the same thing. Once you die, Malak al-Maut, when he comes, he will not ask you your madhab.
Right. Okay. Yeah. Yeah.
Or
I invite you to write a book on inheritance and share this knowledge with us.
No, Shaykh.
Naam Sidi.
Yeah, I just wanted to make one comment there.
Yeah, yeah.
In some of the communities, I'm not going to mention which country or whatever, but once janaza was reaching the maqbara and the daughters objected burial on the ground that, you know,
They start fighting.
her brothers, or, you know, their brothers were refusing to, or this was the precedent like previously. So what I mean to say is, as this gentleman pointed out, I think this is a very good important thing. See, the important thing is, when a person dies, all his amal gets closed, right? Forthwith.
All his
So
own.
let's say, for example, he
all
has
his own
some-
amal. His own amal gets closed.
Yeah, I know.
Not the amal of others for him.
No.
Because you
that's
dua you
true,
make for
that's
him.
true. No, I'm
He gets-
talking about the mass. I'm talking about the mass.
Right.
I'm not talking about this one.
Right.
The point here is actually the wasiya and the deen. Sometimes the people want to make sure that you know, part of that wealth or a small portion of that wealth is given, or at least some kind of certainty is given to the other person, the other heirs, that they will be receiving their due share. You know what I mean? Like, for example, this is one important aspect sometimes the Muslims overlook in some of the communities.
Okay.
And most often daughters do not get as sons get. And this is very one important point. The other point is, you mentioned about the grandmother and about the grandfather. That particular issue also gets this one. And remember, this gentleman had pointed out that, for example, or probably you had pointed out, that there was somebody who died and they had a very large family, okay? And the wasiyas were not fulfilled. How is that retroactive, accountability for the person who dies? Let's say this particular person is the grandchild of the great-grand person who had, let's say, not fulfilled the obligation. So is this particular person responsible if he is rich and is supposed to give the part of his wealth to the previous people in the family? What I mean, is it retroactively applied, or it is proactively applied? Only, for his own family and his sons and daughters. That's very important point too. You understood what I'm saying?
So if somebody died like 100 years ago, you said, should we just distribute it for this family
Yeah,
only?
let's say it was not distributed.
Okay, let's say
Okay,
it was
as
not.
you pointed out.
And now let's fix this family first before doing it retroactively.
Yeah.
Depends what you want. Like, if you say, I want to fix everything, then the Shaykh will have to work on everything. And do it from the moment the
So it is
great-great-great-grandfather.
voluntary for him. It is not necessary. It is not mandatory by law or by Allah subhanahu wa ta'ala, this one. It is not mentioned in this one that, let's say, some of his forefathers.
It's not mentioned, right? But now, if it gets distributed only to this family, they're receiving money that's not theirs, because it belonged to somebody else. It was not distributed.
Now,
It's
who's
not the fault.
going to make a decision on that?
That's why you have the science. You're gonna make the best effort that you can do. نعم سيدي.
هي آية ولكن بعد وصية يوصي بها أو دين. So the some of the scholars who have translated or they have pointed out in the tafsir, the O is بمعنى wow. So it's interchangeable. Where you're saying that according the Hanafiya, their stance regarding the doom, right? Is it their final stance, or is it just اختلاف in
You always kind of find like it's a conversation, right? There's a conversation going on. So all this presentation is just an introduction.
No, I just
But for many cases, you have to, like even the case that this is a very important question.
Yeah.
My concern is Wahid. Only wasiyah. Rasulullah sallallahu alaihi wasallam, before you shut you have to follow him. He made wasiyah how to clean him, to put him in the grave, but he doesn't have any mal or any asset to give to the people. He's supposed to tell them that wasiyah, that's wasiyah. Even if I die, I did my wasiyah myself. The wasiyah, not for the money. Was for money according to Sharia.
No, that's not true.
Huh?
That's not true.
Huh?
No, Sa'd ibn Abi Waqqas radiallahu anhu was about to die.
For myself. I'm talking about myself.
Oh, you're talking about yourself.
Yeah, I myself.
Yeah, okay, that's
Yeah.
fine.
My words is based on Sharia. One third. للرجال مثل حبل الأنثيين. It's mentioned already. You already teach us. And the formula also.
In scenarios,
Huh?
not in every case. In scenarios, there are only 4 scenarios where للذكر مثل حظ الأنثيين. Not in all cases.
If you have 2 boys and 2 girls.
In that scenario.
Yeah.
That's
I'm talking about myself.
all right.
Yeah. My question also about myself. I want to make more clear.
Okay.
Yeah. So, wasiyah cannot, according to what I need. No. Allah already told us in Quran. You already told us. Give us formula. Based on what we learn now, based on that, you give them 1/2, 1/3, 1/6, based on, even if you don't have kalala.
After your wasiyah. In the wasiyah, you can include up to 1/3 of your wealth.
Wasiyah, you do how.
Let me answer.
Okay.
In your case, you go to Shaykh Zahir, write down what you want to do, go to your local imam, have a lawyer, have Sidi Abdul Wahid, and they will say, okay, they will work it out with you for particular cases. Here I'm talking in general. Sounds good? Okay, let's continue. So there's a sequence of claims, right? Secure debts first, and then funeral and burial expenses. And well, I'm talking now in Hanafi. Right? Then unsecured debts, then wills, distribution of heirs, and then there are special cases. So there's a case where you have an acknowledgement of lineage. There's another case if the will exceed the third, what do you do? And finally, the public treasury, Baytul Mal. Baytul Mal is also one of the place where they can receive inheritance. Now, the mal and mawaris to be distributed, it can vary, but this is one option. Ashab al-furud are paid first. Then al-asaba and nasabiyya. Nasabiyya is based on lineage. And then you do a rad ala zul furud. It's a kind of return. Then for those who give inheritance to zawil arham, they do zawil arham. Then you do a rad on one of the spouses, if necessary, if needed. Then you do al-asab al-sababiyya, the pattern, whether male or female, they don't exist today. And then you execute the will exceeding 1/3. What do you do? If it exceeds 1/3, then there is a process either to refuse it completely or to, if approved by the heirs, they say, we have no problem if he gives more than 1/3 to somebody else. They need to approve it. And Baytul Mal, the public treasury. The legal framework. Now, say.
Sorry, could you define the mal, the meaning of that?
Mal
Mal
is what can be stored, what can be given, and what can be. So what we mentioned before about mal, it's any assets or cash that the humans naturally inclined toward can be withheld / given, and crucially can be stored at the time of need. Can be stored.
anything liquid, perhaps, that you can liquidate in today's terms, like assets, like
Yeah, that's mal.
Yeah.
That's mal. Your house is a mal. Your land is a mal. Your car is a mal. Your money is a mal. All these. In some other schools, they may say it in a completely different way. They say, كل طاهر ينتفع به. Anything pure that is beneficial, that's wealth. So if you have a chair, it's طاهر ينتفع به, you can benefit from it, that's wealth. كل طاهر ينتفع به. Why do they focus on these precise definitions? Because sometimes they want to say that benefits are not part of money. Benefits. Like, for example, a lease. If you're renting a home, a lease. So in some schools, is this wealth, is this not wealth? They say, well, it's not wealth because they cannot be stored. Cannot be stored because they expire with time. Right? So there are benefits. Are benefits like hard hard money or not? Yes, sister.
The acknowledgement of lineage, like how does it work? Like right after the person dies, or
Acknowledgement of yeah, even after the person dies, somebody comes and says, هذا ابن أخي. You see a person, say, this is my nephew. He is the son of the deceased. Well, that person cannot have a lineage, right? So it needs to be someone who nobody knows his lineage. So there is a possibility that you can claim. But when you do this acknowledgement of lineage, if you say this is my son, it becomes your son. But if you say this is the son of my brother, you're now attributing somebody to someone else. So is it accepted, is it not accepted? There's a process. Right, so now let's look at the legal framework, and here we can start the inheritance. Anything we did before that, we're getting to this. When we talk about inheritance, there are pillars, which is arkan, there are causes, asbab, there are conditions, shurut, and there are impediments, mawani'. So the pillars, the arkan, are the inner components. They're part of the mahiyya. The conditions are components, but they're outside the mahiyya. Outside. There are prerequisites. And causes is the cause of inheritance. Why does this person inherit? And impediments. Sometimes there's an impediment to inheritance. So we have the pillars, the causes. We have the pillars, we have the causes. We have the conditions, and we have the impediments. So what are the inner components of inheritance? There are three. First of all, we need to have a deceased. We need to have a deceased. Meaning what? Meaning we have to be certain that he died. So, well, isn't that obvious? Yeah, but we need to be certain of his death. Right? So we need to have a deceased that we're either certain of his death, or their presumed death as per the court. Somebody disappeared or under the rubble, are they dead or not dead? So if those of you that remember flight MH370, flight MH370 from Kuala Lumpur to Beijing, it took place in 2015, right? Disappeared overnight. 328 days later, the government of Malaysia issued a statement that we consider those people now to be dead. So by a judgment from the court and from the government. At that moment now you can distribute their wealth, not because the plane disappeared. So you have to either know that this person has died either حقيقة أو حكما أو تقديرا, presumed death. Also, we need to have a waris, a legal heir, i.e. we need to be certain that the legal heir was alive at the time of death of the deceased. Because if they die before, they are not heirs anymore. And we need to have a maruth, an estate. We need to have some kind of asset, some kind of money that we can distribute. Right? Yeah. So we have the pillars and the conditions. So the pillars, as we mentioned, they're the internal components of inheritance. You need to have the deceased, the heir, and the estate. The conditions are external prerequisites. And we have causes. Who can inherit, basically? The cause is who can inherit. What is the basis for inheritance? Well, the basis are three. Either marriage, a valid marriage. And by marriage we mean a contract, a valid marriage contract. Whether they've seen each other or not, whether they've consummated the marriage or not, as soon as there is a contract, she inherits, he inherits. And nasab, lineage. So, nasab, they need to relate to the deceased. There's a relationship, there's a link between the heir and the deceased. And this link can be direct or can be remote, can be immediate or can be remote. And then the third one is loyalty, patronage for, in the old days, masters and slaves, if a slave is free. So for today, basically, those that inherit are ashabul furudi wal asabat. Those that inherit because of marriage, because of a valid marriage contract, or those that can inherit because of lineage. So these are the three causes of inheritance. Marriage, i.e. a valid contract. And this remains active during a revocable divorce. Because if it's talaq raj'i, i.e. he can go back to her and she can go back to him at any point. So the marriage contract is still valid. The divorce completely hasn't taken place yet. So during the waiting period. The second one is lineage. This is the blood relation established by either formal acknowledgement, iqrar, what they call iqrar, or established by blood. And loyalty. Now the mawani', the conditions are death of the deceased. So this is the condition. We need to make sure that the deceased has died. We need to make sure that the heir is alive. And we need to make sure there is no mani', there is an absence of all impediments. Now, what are the impediments? The impediments in the old days used to be slavery. So historically, the slavery after Islam, before Islam, there are many ways to make people slaves. After Islam, only one way. Everything was abolished, only one way, and it was gradually transitioned into freeing slaves. And we can talk about the wisdom behind that at that time, or the transition period. So slavery, and then al-qatlu, homicide. Homicide. So al-qatilu la yaris. Al-qatilu la yaris. In some schools, al-qatilu la yaris, they take it like to extreme. So even if you give a testimony in the court of law that causes death, you're barred from inheritance. You don't inherit. Even if you're the judge and you're related to the accused, and you give the judgment for him to be executed, you cannot inherit.
What about Ibn al-Haram?
What? Ibn Haram.
without nikah, he born.
Ibn Haram is not part of this. Ibn al-Haram doesn't enter into this. Ibn al-Haram is not part of the inheritance.
He cannot
No inheritance.
same like Khatib.
So he has to be a legitimate child. Legitimate child.
I know. But Ibn Haram ما له أي علاقة بالوراثة.
He cannot get any share from the inheritance. Maybe he wants to give him something during his life, or
1/3, which
or
is
whatever, but not part of the inheritance.
yes, but
So usually they, in terms of when it comes to homicide, they consider aggressive, hostile, intentional killing. القتل العمد والعدوان, for example. But there are positions that any direct killing generally bars inheritance. Like even if you kill him accidentally, you hit him by car. If you hit, his son, or you're his father, or your her husband, or she's your wife, there's a conflict of interest. So many ulama would say no, they cannot inherit. And thirdly, اختلاف دين, difference of religion. So in terms of difference of religion, they do not inherit as part of the inheritance. They can be dealt with in wasiyah, in will. So this generally prevents mutual inheritance. And there are some positions that Muslims can inherit from non-Muslims, but not vice versa. Right. Now let's take this example. I think we mentioned it. A special case, flight MH370, after 327 days, 328 days. They said all of its 239 passengers and crew were presumed deaths. Presumed dead. That's a condition, huh? So once we now have a judgment from the court or judgment from the government, or you've seen the person died in front of you, then you're sure that he died, you can now start distributing and go through the procedures of burial, doing salat, the janaza, and settling the debts, and executing the will, etc. Okay, now we talked about mawani', right? Mawani' is impediments. Impediments. If someone is a killer, they do not inherit. All right. This is a mawani' actually is falls under the chapter of exclusion, the chapter of hajr. And usually, scholars, can wait to talk about mawani' in that chapter. But since we need it for the legal framework, what they did, they took it out of that chapter and put it in front, in mawani', and then left the details, other details later on. So there's something called mahroom and something called mahjub. Mahroom is barred, disqualified. And mahjub is excluded, but not disqualified, just excluded. So when we talk about impediments, we're saying that this person is mahjub, is excluded, but there's a cause behind their exclusion. Either because they're a slave, or there's an attribute, there's a cause, or because they killed someone. They killed the deceased, or they're related to killing the deceased, and that's why they're barred, they're disqualified, completely disqualified, as if they don't exist. They might as well be dead, as far as inheritance is concerned. So let's take an example. X dies, leaving a wife, a full brother, and a son. So let's take two scenarios. The first scenario, the son killed his father. Since the son killed his father, he gets big zero. Actually, he's barred, he's disqualified. The wife usually gets 1/8 because there's a son. But since the son gets 0, she's going to get a fourth, a quarter. And the germane brother will get the residue. But if the son is a normal son, he did not kill his father, then the wife gets 1/8, the full brother gets 0, and the son gets the residue, gets 7/8. So now he went from being completely disqualified and barred to being a normal heir. And as a normal heir, the brother of the deceased now gets excluded. This is exclusion by person. Because of the presence of another person, they get excluded. But they're still part of the family. Let's take another example. X dies, leaving a father, a mother, and germane brothers. Full brothers. Right? So the mother gets 1/6, and the father gets actually the residue, and the germane brothers get 0. They're excluded. So how does exclusion work? Exclusion of heirs is of two types. It's exclusion bil wasf, i.e. by cause or attribute, or exclusion bil shakhs, by person. The exclusion bil wasf, this is what we call mawani', impediments. So there is a wasf, there is a cause, there is an attribute that made this person disqualified and barred them completely from inheritance, either slavery or difference of religion or homicide. The exclusion bil shakhs, you can have a full exclusion or partial exclusion. And the excluded can also exclude others. So he's not completely barred or disqualified. And there are situations in inheritance that if you do iqrar, if you acknowledge the lineage of another person, you end up excluding yourself. So you end up working against your own inheritance. So we have exclusion b'shakhs, by person, either a full exclusion, and this includes 11 males and 5 females can be excluded completely, fully. And partial exclusion, we said the mother, the husband, the wife, it's mentioned in the Quran, the mother gets a third, but if some other people are present, she gets a sixth. So she gets excluded partially from her full share. She only gets a partial share. Same thing with the husband and the wife. And the wife gets a quarter, but if they are in the presence of other heirs, she may get an eighth. The husband gets a quarter or half in the presence of other heirs, he gets a quarter, i.e. he gets partially excluded from the full amount. Any questions on exclusion?
Brother, thanks for sharing words of wisdom.
Hmm?
Thanks for sharing your words of wisdom. I just I read you had having copyrights on your slides.
Hmm.
I took some of the pictures. I'm allowed to take those
Yes,
pictures.
for your own use.
Yeah.
Let's look now at the classification of legal heirs. So basically, classification of heirs. So based on importance, we have primary heirs. The primary heirs are spouses, parents, children. Those are never excluded. And then we have secondary heirs, others. Or we can look at the family based on the nature of relationships. Relations by blood, relations by marriage. And we can look also in terms of numbers. Ashabul Furud, wal Asabat, and Zawul Arham. Ashabul Furud wal Asabat are 17 categories that can be expanded into 24 or 25. And Zawul Arham, i.e. distant relatives, those are about 48 people. So what we have, the primary heirs are never excluded. Secondary heirs can be excluded. Ashabul Furud wal Asabat are 25 people. And Zawul Arham are 48. if we look at it in the chart, this is the chart. Family, we have the inner family and the outer family. The inner family, we have al-asabat. Those are males that inherit by residue, and sometimes females can become asaba and also inherit by residue and get even the full estate. And ashab al-furud, those that have fixed share, and then they get more than their fixed share either through rad or awl or something else. Who are ashab al-furud? Ashab al-furud are three types: primary, secondary, substitute. Primary, like the father, mother, i.e., this is ubuwa, parenthood, husband, wife, spousehood, and daughter, childrenhood. Secondary, we have the full sister, parental sister, maternal sister, and maternal brothers. And substitute, the grandfather can substitute for the father, the grandmother can substitute for someone else, the granddaughter can substitute for the daughter. So if some of the heir are not present, we can always find a substitute. But from the parenthood, we want one representative, and if that representative is not present, then someone else can substitute for him. The asabat are either asaba that is causal by sabab, or asaba by nasab, that is lineal. And we have three types. Asaba bin nafis, they get the residue by themselves, or asaba ma'al ghayr, this is an accompanying residue, or asaba bil ghayr, this is residue by another. We have some examples. This is the whole family, just the inner family, and there's the outer family. And so if we look at ashab al-furud wal asabat, there are 10 categories of men who inherit that can be expanded to 15 people. Who are they? The son, the son's son, and so on to the youngest generation born. The father, the grandfather, and so on to the oldest generation alive. Brother, the son of a brother, the paternal uncle, and his son, the husband, and the person who set free a slave. So when you look at, for example, the grandfather could be, or say the brother could be so in any case, this can be expanded to 15 people. And for women, 7 categories that can be expanded to 10 people. So when we talk about the daughter of the son, the mother, the grandmother, the sister could be full sister, half sister, paternal sister, maternal sister, a wife, and a lady who set free a slave. Any questions on this? Try to go quickly now over.
Not a question, but because obviously now it's a growing trend for Muslims who are adopting and they employ
Rada'a, yeah. Breastfeeding is not a cause for inheritance.
So what happens to those children in terms of their estates? Because obviously their parents are out of the picture. So now, it's just wasiya, like how
wasiya or something else during their life. But in the Canadian law, they may take you to court and inherit. So you have to work it out with this guy. Now, sister.
But in this case, the person who is less is usually the children, and they always inherit, so they have money to take care of that cost. It's already embedded in the laws. Right? I mean,
he's talking about adoption, right? If a foster kid. If you took a kid.
Oh, foster, not.
Yeah, foster.
Okay.
Right.
Sorry.
Not your own
But
children.
in the case of where the child passes away, then according to Canadian law, of course, by default, the parent will inherit from,
Yeah.
from the adopted parent, but Islamically, they're also the parents, right? So, but obviously, the implications all are dependent on whatever the child writes in his own will.
Right. Let's look at the mathematical engine behind this. So in terms of the mathematical engine, we have three things. We have awl, and we have rad. Awl is an increase, rad is return, and we have tasheeh, correction. We do a correction. So, talk about those things. So, awl is basically, this is a proportional reduction. And rad is when the wealth is returned. So rad is a fundamental concept in Islamic inheritance law that occurs when the total fixed shares, al-furud, assigned to heirs are less than the total estate. So you distribute the shares and there's money left. So it doesn't exhaust the total estate. Right. And there are no asaba to take the remainder, to take the residue. So there is no asaba to claim the surplus. So in such cases, the remaining wealth is returned to the fixed share heirs in proportion to their original shares. And tasheeh is correction or adjustment. This is a mathematical process to ensure that the shares of all heirs are expressed in whole numbers. There are no like decimal points. So can go over more details. So the awl is when the shares exceed the total estate, then what do? We do a proportional reduction. So you have 1/2, 1/4, 1/8, 2/3, 1/3, 1/6, and the common denominator is 24 or 12 or 6 or 9. But then the number of shares are 13 or 27, or so they exceed. So what do? So you do a reduction. You do a reduction so that everybody gets the same proportion as per the original structure. So it's like a capital structure in companies. You can increase the number of shares or reduce the number of shares by increasing the value of the share or reducing the value of the share. Rad and return is when the total fixed shares assigned to heirs are less than the estate. And there's a surplus. What do? Then you return those to ashab al-furud. And there is no residue heirs present to claim the surplus. So rad is the opposite of awl. So awl occurs when the shares exceed the total estate. Rad occurs when the shares are less than the total estate. And there's absence of residue. And tasheeh, we want to make sure that we give people like, an exact number, not decimal points. Let's take an example of rad. A man dies leaving a wife and a daughter. Well, first we distribute ashab al-furud, we give the fixed shares. So the wife, because there is a daughter, the wife gets an 8, not a 4. The daughter, because she's alone, she gets a half. Well, an 8.5 is less than 1. Then she gets 3/8 by way of rent. Gets returned to the daughter by way of rent. The daughter ends up getting 7 out of 8, and the wife gets 1 out of 8. 1/8. So let's say assume the estate is $1,000. The wife gets $125. The daughter originally gets $500 as her share, and gets $375 by way of return, because there is a surplus. So she gets a surplus. Let's reverse it now and assume that a wife dies, or a woman dies, leaving a husband and a son. What happens? The husband gets a quarter because there's a son, it doesn't get half. The son, because he's a asaba, gets 3/4. He's a residue, he takes everything. So the son actually gets 6 out of 8. 6 portions out of 8, which is 3/4. The $1,000 gets distributed this way. The husband gets $250, and the son gets $750. So the surplus is distributed among the fixed share heirs, ashab al-furud, and the exception is of spouses. But all other ashab al-furud, they get this return. In this case, you'll see that the daughter actually is inheriting more than the son. Why? Because she has no brother to take care of her. And recall this idea of financial need and financial burden. If there's a brother to take care of her, it's mandatory on him to take care of her, then there's a 2-to-1 ratio that applies. And if he gets married, he has to take care also of his family. And if she gets married, then she doesn't need him anymore. And she gets mahar, and she gets other stuff. And she doesn't have to spend on her own house from her own money. Okay. Let's take some examples. The shared case, or called al-mushtaraka. Person dies, leaving a husband. Say a woman dies, leaving a husband, and then uterine siblings. Half siblings from their mother's side, and full siblings. Full siblings. So this took place at the time of Umar radiallahu anhu. It's called al-mas'alatu al-mushtaraka or al-mas'alatu al-hajariyya. So in the Hanafi, what they do is the husband gets a half, the mother gets a sixth, and the uterine siblings get a third, and the full siblings get 0. And it's similar, I believe, in the Hanbali. The Jumhur, the mother gets an 8, and the U siblings and the G siblings, they share a third. And the husband gets, this is probably wrong from the previous one. The husband gets a fixed share. Let's take another example. This is called al-mas'alatu al-minbariyya. Imam Ali was on the minbar, on the pulpit, and somebody asked him, and he gave him the answer right away, without having to prepare and think about it, because he was smarter than us. Person dies, leaving a wife, 2 daughters, a father and a mother. And here we apply the principle of awd. And we do a proportional reduction. So what do? We have, the wife gets 1/8 because they are offspring. The 2 daughters get 2/3. The father gets 1/6. The mother gets 1/6. They have to get a 6th, because it's a farad, and it's mentioned in the Quran directly, clearly. But if you add this, it's more than the estate, more than 1, right? It's more than 1. So what do? We use awd. So the Jumhur, all scholars agree on this. and we use hour. So 1/8 is like 3/24. And 2/3 is like 16/24. And we have 4/24 and 4/24. 1/6 is 4/24. Now if you add 3 plus 16, that's 19, plus 4, 23, plus 4, that's 27. So you change the denominator from 24 to 27. And you distribute it in this way. So everybody gets a reduction, but they keep the number of shares, basically 3. But it's not 3 out of 24, it's now 3 out of 27. So it's a proportional reduction due to the crowding of shares.
In the grand scheme of things, it's still the same amount.
Yeah, exactly, it's the same amount. Yeah. It is like capital structure in companies. You have one share worth 1 million or 1 million shares, each one worth $1 each. The amount is still the same. Only the number have changed. That appears better for investors. Now, sister.
The comment is something always bothers me because in reality, you're not getting the exact share. It's how it's really.
You're getting the amount, the same amount. Yeah.
You're not getting the actual, the $2 getting 2/3 of the actual amount. It's not, because if you look, the fraction is not 2/3 of the total.
Yeah. So now, all of these are competing for the same one, right? So if you give the sister 2/3, then what are you going to give the mother? 0?
No, I know this.
Quran says no, you have to give her something.
I know, but what they're saying going back is this.
Right.
It's not fair.
Well, if you have any problem, then the Zayd ibn Sabit and Umar and Ali will be very happy to discuss with
I
you.
wanted to know what was their thinking, what is the, because I see this is seems the only way, which I saw, but I'm just wondering.
Do the math. Like, go on yourself. Yeah. Assume the estate is $27. Okay, and compute these shares, and then do the math and.
Yeah, would it be 2/3? Or would it be the same? Or
Won't be 2/3. Exactly.
It would be less.
But in relation to everybody else, they have the same percentage.
Yes.
Right. The Akdariya case is a difficult case because it disturbed Sayyiduna Zayd ibn Sabit. All his principles, all his framework of inheritance was disturbed by this case. And he had to do a lot of gymnastics to solve it. And Sayyiduna Umar followed his calculation. And it became the standards at the time of Sayyidina Umar and others. So assume we have a case where someone dies, leaving a husband, a mother, a grandfather, and a full sister. Well, if you follow the text, the husband gets half, because there is no offspring. The mother gets a third, not a sixth, because there is no offspring. The grandfather gets a sixth. And the full sister gets a big 0. Gets a big 0. So this is the only case where you have to do gymnastics on the furud, the fixed share, and you have to do gymnastics on the awd. Simultaneously. The Maliki and Shafi'i, they follow Zayd ibn Sabit and Umar and the companions. Many of these, in terms of companions, those that were experts in inheritance are Imam Ali radiallahu anhu, Abdullah ibn Mas'ud, Zayd ibn Sabit, Umar ibn al-Khattab, and Abu Bakr as-Siddiq. We have Ibn Abbas also later on. Abdullah ibn Mas'ud, some of his opinions in inheritance, because he has infiradat, are abandoned. And nobody mentioned it. although he's very great. Some of the positions of the Hanafis, Imam Abu Hanifa is actually representing Abu Bakr Siddiq. It's the same position as Abu Bakr Siddiq himself. And Imam Abu Hanifa, in his own ijtihad, reached the same conclusion as Abu Bakr Siddiq radiallahu anhu. And then we have Zayd ibn Thabit, like the majority, 95% of cases is Zayd ibn Thabit. All scholars agree on him. Afradukum Zayd. Afradukum Zayd. And Imam Ali, you also have his positions a lot. Ibn Abbas has a lot of infiradat and came later on as well. Has a lot of his own personal gymnastics, 2 cases. Scholars are aware of it and they can benefit from them, from these amazing positions when needed. But they're not applied as a rule of thumb. They may be applied as a case-by-case scenarios. So the Maliki and Shafi'i, what they did is, okay, we give 1/2, we give 1/3, we give the grandfather 1/6, and we give the full sister 1/2. And then we do awl. We do awl. We go from 6 to 9. 6 to 9 doesn't solve it. Then we multiply by 3 and we go to 27. And 27 solves it. So, for example, with awl, it becomes like a third. 9 over 27, 6 over 27, 8 over 27, and 4 over 27. And if you add them, 9 plus 6 is 15, plus 8 is 23, plus 4 is 27. We can go through, this case is a very good case to train. We can go step by step and go like over the 6th step or 7th step that one has to go through before reaching that conclusion. And the rationale behind it. And how it connects the rules of inheritance together. Al-Mukharaja. Okay. Al-Mukharaja, Takharuj, is, let's say in this case, X dies leaving a husband, a mother, a grandfather, and a full sister. The wife, there is 2 sons, 2 daughters. One of the sons said, you know what, I don't want all this headache. Just give me an amount, and you guys divide the inheritance amongst yourselves. So I just want to exit. So it's like an exit settlement. So then we end up with a wife, 1 son, and 2 daughters. So what we do, we say, okay, wait, we're going to divide it the way it is, assuming that you're still inheriting. And then we're going to take you out. And there are those of the heirs that will give you the settlement amount. We're going to take your portion that you're going to inherit and distribute it on them. And if you do this exercise, you have to do also tasheeh. You have to do correction and make sure that you don't end up with a fraction or a decimal point. So you keep on dividing the pie until you get a share that is a full integer, full number. So you can do the example. Let's move to one. Now, let's take this case. The debts exceeding the estate case. So somebody left $1 million, but his debts are $1 million. There is nothing left to be divided. Let's go home. So no inheritance except after payment of debts, basically. Oh, now this is a very good case. Very good. The question here, when someone dies, is the estate transferred immediately to heirs burdened by the debt, or the estate remains legally owned by the deceased until debts are cleared? So there's a debate and conversation among the scholars, and the Hanafi side with the first one, and the Jumhur side with the other one. Now, the estate is transferred, burdened by debts. So let's take an example. X dies, leaving a property was worth $50,000, but his debts are $100,000. Now, the property value increases, say to $150,000. Who gets this amount? The creditors or the heirs? Because now the property was worth $50,000, now it's worth $150,000. They can pay the debts, and there is $50,000 surplus. What do we do with this? So the delta belongs to the creditors, according to the Hanafis, and belong to the heirs, according to the majority, Jumhur. And no inheritance except after payment of debts. That's the question. Is the estate transferred burdened by debts or not? Remember the first question we asked? If there's a long dispute and there is debts involved, who gets paid, the creditors or the heirs? First question. Let's take another one. Problematic heirs case. Problematic one. Let's say you have somebody dies leaving a wife, 2 daughters, a mother, and a fetus. The fetus could be male or female, could be twins, could be alive or dead upon arrival, upon birth. So here what we have to do also, we have to do, so what they apply this idea of certainty and precaution. There's takhawufun wa zakah, and there's ihtiyat. And then the denominator will be increased to 288 or 2,592, depending on the method you use. You can go through this and find out the answers for yourself. This could be a good exercise. The khunsa case. Somebody that's how do you say this? Hermaphrodite case. Hermaphrodite, yeah. So a person dies leaving a father, a grandmother, and a hermaphrodite child. So what do? We use the certainty principle. This child, we still don't know whether they're male or female. So we also do certainty and precaution. And in the Hanafi, we give the child the lesser share based on. So we use the caution principle. And in the Maliki, for example, I'm putting in the Maliki. The Maliki would say, let's assume he's a male. What does he get? Let's assume he's a female. What does he get? We give him half a male and half a female, basically an average. They give him an average. A munasakha case where you have successive deaths, multiple deaths prior to distribution. Say somebody leaves a wife, a full brother, and a half sister. The wife, full brother, and the paternal sister. And then the full brother dies. So now you have to do 2 cases. You distribute as if the brother is still alive, and then you assume the brother dies, his share now gets redistributed to his own heirs. This is the munasakha case. Multiple deaths prior to distribution. So solve the first case, then treat the second deceased share as a new subcase. Correct it, do tasheeh on it, to create a unified base for both. That's a good exercise. That's a simple munasakhat case. There are complicated munasakhat cases. Mass casualty. Drowning, fire, accident. Father and son die in a car accident. It's unknown who died first. They do not inherit from one another. We need to know exactly who died first before we apply inheritance. No mutual inheritance between them. Let's go to return and proportional. This is Radiyya, Masala Radiyya. Let's do Let's do these two cases and we stop. This is called al-mas'alatu al-dinariyya. Al-dinariyya al-sughra and al-dinariyya al-kubra. Dinariyya from dinar, gold coin. So assume the tarika is 17 gold coins. So a person dies leaving 3 wives, 2 grandmothers, 8 paternal sisters, 8 half-sisters, and 4 maternal sisters, 4 half-sisters as well. What do they get? They get a dinar each, a gold coin each. Each one gets a gold coin. How so? Well, all scholars agree on this. The 3 wives get a quarter. Why? Because there are the 2 grandmothers get a sixth. The 8 paternal sisters get 2/3, and the 4 maternal sisters get 1/3. And then we do awl, 12 becomes 17, and each one gets 1 gold coin. So after correction, the 3 wives get 8 coins. 3 coins, sorry. The 2 grandmothers gets 2 coins. The 8 full sisters get 8 coins, and the 4 sisters get 4 coins. So each one gets 1 coin. And everyone is happy. The second one, the dinariya kubra, this is a case that took place at the time of Imam Ali, and Shaykh al-Qadi was the judge at that time. So a family or heirs went to Shaykh and told him, we have described their case, and he distributed the inheritance among them and gave one person 1 dinar. Gave the full sister, the one full sister, i.e. full sister, they share the same mother and father. She get 1 dinar. And the tarika was 600 gold dinars, 600 gold coins. So the full sister said, did I get only 1 gold coin out of 600? There must be something wrong. So she went to Imam Ali and she told him, you know, I think I've been dealt with unjustly. He said, what's the problem? He said, I got 1 dinar. I went to Qadi Shaykh and he only gave me 1 gold coin. And I think he messed up. He thought about it for a second and he said, is your case that the estate is 600 gold coins and there's a deceased that left a wife, a mother, 2 daughters, 12 full brothers, and you? She said, yeah, how did you know? He said, then his calculation is correct. You only get 1 dinar. And he did it on the spot. He reversed engineer actually from, usually when my children, let me talk about my daughters. My daughters come to me, they're 3 years old, 5 years old, and she says, she hit me. That's the only information you have. That's the only piece of information you have. And now, okay, why did she hit you? Like, how did this happen? Like, none of that is available to you. Same thing here. So she went to him and says, I only got 1 dinar. So there must be something wrong. So Imam Ali alayhi salam, he immediately reversed engineered in his head the full case. So that's what happened actually. So what Shaykh did, he gave the wife 1/8, gave the mother 1/6, gave the 2 daughters 2/3, and gave the 12 full brothers 1/3. After correction, the wife gets 75, which is 1/8. The mother gets 100, which is 1/6. The 2 daughters get 300, which is 1/2. Sorry, 400. Sorry. Needs to be 400, which is 2/3. The 12 full brothers, they only got 24, or 1/3. What's 1/3? Because there's tasheeh and there's correction. So the denominator of 24 gets corrected to 600, and the full sister gets 1 gold coin. So this is the story. The full sister didn't agree with Qadi Shuraih and appealed to Imam Ali to resolve her case. Imam Ali did resolve it. Walhamdulillah Rabbil Alamin. Any question? No.
What would the full sisters share be?
The full sister, you have to review it, what she gets. No. So in short, like the straightforward cases are easy to deal with, but there are some intricate cases that you have to, and sometimes you have to apply awl, sometimes you have to apply red, sometimes you have to do tasheeh, sometimes you have to do adjustment, and then there are some cases that will disturb your qawaid, right? You apply all the qawaid and you still don't, the loop is not closed. So then you have to look now, go back and see how the companions dealt with similar cases and the ulama, then close the loop. There are people that can do that. And we need people like that here. Shaykh Abdul Wahid and Shaykh Zahir will do that. And Ayana will make sure that everything is kosher as per the Canadian law. Now for particular cases, like if somebody has his own case, what I would recommend is write it down. Write it down. Write down exactly what you want to do before you die or part of your will, and show it to the local imam. And they'll help you, and then show it to the lawyer, and he'll structure it in a way that will either reduce your tax or make sure the process is easy, because you have to choose a person who's going to act as an executor that and make sure everything is distributed properly. You want to make their life easy, not too difficult. So if everything is documented, everything is clear, then with the help of the local imam and the lawyer, they can make sure that everything is smooth. Allahu A'lam.
Barakallah.
Allah yabin.
I just wanted to mention that one thing.
Naam.
Found out, I'm not speaking in capacity
No.
here, but I just wanted to say that.
You're the Shaykh of Brampton.
No. So I just wanted to say that so all of this is required overarching, which is that a person is considerate of the Sharia, because obviously the society we live in gives free rein to people to do whatever they want. So I think in terms of education, miras is one component, and I guess the overarching education would be that people are aware that we have to stand before Allah subhanahu wa ta'ala and give account for the action. The other thing that I wanted to mention